Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Wednesday. Hey, so this is a Diddy update. There have been a few filings that has been submitted to the court, and the judge pretty much ruled on two issues. The first issue was Diddy so the judge actually ordered for the government to provide the defense counsel the steps that were taken by the investigator as to how he obtained or she obtained. The attorney-client privilege documents from Diddy Cell. And then the other issue is the defense when they submitted a motion to amend the protective order to pretty much get their hands on the freak off tapes. And the judge has made a ruling on that. Let's tap right on into it. So the first thing, like I stated, we're going to talk about is the investigator steps in obtaining. So the judge put out an order, Judge Subterranean. It stated that the court is in receipt of the government December 20th, 2024 ex parte letter concerning certain investigative steps it took based on Combs's notes. Given the content of the letter, it is unclear why it cannot be shared with the defense in some form. By January 31st, 2025, the government should either provide defendant with a letter describing at the level of detail that is appropriate what steps were taken. And if they can't do that, then they would have to provide an explanation to the court as to why they can't do that. So that is still going on. But in bigger news, the last that we left off on is Diddy's attorney, Mark Agnifilio, submitted a request to modify the protective order because he's seen the freak off tapes and one victim's freak off tapes. Let's put it that way. There were a total of 9 tapes that were reviewed in the government's possession. So defense counsel actually had to set up a time to go view the video. So upon the defense going to go view them, they noticed that the audio was off, the video quality was off, and the victim one, aka Cassie, was thoroughly enjoying herself. And so he just thought that, hey, these aren't what y'all were really talking about as far as the real freak off tapes. So we should be able to get copies of those. We should be able to obtain copies and manipulate them as needed, such as fix the audio, fix the video quality or the lighting, and so on and so forth. That's what they were trying to do. But the government then responded and say, this is attorney uh eyes only. This should not be shared with anybody else, including your defendant. Okay, so I don't know what it is about them wanting to get their hands on these tapes, but it's crazy. But without further ado, let's listen to what transpired over the past 2 days. So this letter was actually submitted yesterday by the government, and it's to Judge Subramanian, and it states that the government respectfully writes in response to the defendant's motion to modify the terms of the protective order to require the government to electronically produce certain videos described in paragraphs 12A and 12C of the indictment. Oh, and I forgot to add, also, the government did ask for Mark Agnifilio or the defense team to pretty much their response to the government. Well, their reply to the government's opposition to amend, Mark Agnifilio pretty much had very keen details as to what was in those freak off tapes. And so the government came back and say, you are violating the protective order. You need to go back and you need to redact certain things and refile this. But anywho, let me continue. The court should deny this request. So the government is asking for the court to deny defendants modify the terms of the protective order in regards to obtaining the electronic videos that are in their possession. Based on the content alone, good cause exists for the protective order's current designation of these highly sensitive videos as available for inspection only. Moreover, the necessity of stringent protections for the video is underscored by the defendant's blatant disregard of the protective order in his motion, which subjectively described the content of the inspection only videos without proper redactions. Background. So, the indictment and the videos. Indictment 24, and that's the case number that we're currently in, was filed on September 12th, 2024, after a grand jury found probable cause that the defendant had committed one, racketeering conspiracy, which is in violation of Title 18 of the United States Code, Section 1962D. Two, X trafficking, which is in violation of the 18 of the United States Code, Section 1591. And two, and number three, interstate transportation to engage in prostitution, which is also in violation of Title 18 of the United States Code, Section 2421A and 2. As alleged in count one, the defendant participated in a racketeering conspiracy from at least approximately 2008 to approximately 2024. Specifically, as alleged, the defendant, often assisted by other members and associates of the racketeering enterprise, engaged in ex trafficking and acts of violence, including kidnapping, arson, and physical violence, among other crimes. With respect to the alleged ex trafficking activity, the defendant used force, threats of force, and coercion to cause women to engage in commercial X, which included X acts with male commercial X workers that the defendant referred to as freak offs. The defendant ensured that female victims participated in freak-offs through coercion and violence, including by supplying female victims with controlled substances, subjecting female victims to physical, emotional, and verbal abuse, and controlling female victims' careers, livelihoods, and housing. The defendant also filmed and kept videos of victims engaging in freak offs and used these sensitive and embarrassing recordings as collateral to ensure the continued obedience and silence of victims. On September 16, 2024, the defendant was arrested in connection with the aforementioned charges, and the indictment was unsealed the following day. Now, let's talk about the protective order. Shortly after the defendant's arrest, the parties began negotiating the terms of the protective order. Those negotiations included discussions about how sexually explicit videos and images, including those depicting freak-offs, should be classified under the protective order. Throughout those negotiations, the government balanced the defendant's reasonable request to be able to review the sexually explicit videos with his counsel against the need for appropriate protections for the videos, given their extremely sensitive nature. In particular, the government communicated to the defense that, consistent with the Crime Victims' Right Act, a small subset of these videos, 10 in total, the inspection only videos, required particular protection. The government noted that victim one had specifically requested that the inspection only videos not be electronically shared or reproduced in order to protect victim one privacy. The inspection only videos were recovered from an electronic device that victim one had provided to the government. The videos vary in length but total less than 2 hours of footage. On October 4th, 2024, the parties agreed to the protective order. That protective order provided that all visual depictions, including any photograph, film, video, picture, or image of sexually explicit conduct or nudity, will be designated as attorney eyes only, regardless of whether it has been designated as such by government, with the exception of one, any such material located on defendant's devices or cloud accounts, which would be designated as attorney possession only, with certain additional protections, and two, any videos described in paragraphs 12A and 12C of the indictment of or images of the same that were not located on defendant's device or cloud accounts, which would be made available for inspection only and not electronically produced, and which the defendant and his counsel could review in person while monitored by law enforcement officials. The court entered this protective order on October 7th, 2024. I swear, as reading this, I'm like, they probably wanted their hands on that video and those videos so it can somehow get leaked to the public. That's all I gotta say. Let me see. Oh, I did not even read any of the footnotes. Okay, so footnotes. So it says 10 videos in total. So let's see. So the motion notes that there are only 9 videos designated as inspection only. However, the government identified a 10th such video, of which it notified defense counsel on December 16th, 2024. Okay, so that takes care of that. And the additional protections as it pertained to any material that was found on the defendant's device or cloud. So let's see. So it says specifically, it provided that the defendant may view the materials under the following agreed upon conditions. The material is viewed by the defendant in the presence of defense counsel. 2. On a device approved by the government. 3. In an approved private room in the jail facility or other facility approved by the government. And 4, defense counsel ensures that such material will not be accessible or viewable by incarcerated individuals other than the defendant, visitors, or others who are not part of the defense. See, I think the issue with this is that was the whole purpose of Cassie's videos being one, she specifically asked that they not be electronically shared. And if you guys already talked about this, the contents of the protective order the day after Diddy was arrested, then I think that you should abide by it. Now, every so often the protective order is going to have to be reviewed and amended just based off of what comes out, but she asked the nature of the videos, as they said, attorney eyes only, not your defendant, not nothing. But I strongly feel that if they would have got their hands on those videos, they would have shared it with Diddy, and somehow, some way, it would have been leaked to the public. Um, and then let me see. The defendant and his counsel could review in person while monitored by law enforcement. So it says to prevent. So the reason why they're saying that you can it's available for inspection, meaning that you set up a time for you to come in and to review. But this was to protect victim one privacy. The sole reference to the inspection only materials was redacted from the publicly filed protective order. Oh, Lord. A few weeks after the protective order was entered, the parties scheduled time for the defendant and defense counsel to review these inspection only videos. The defendant reviewed the inspection only videos on both November 20th, 2024 and December 13th, 2024, consistent with the terms of the protective order. The defendant has not made any additional requests to view the inspection only videos. All right, so let's talk about the motion. The motion to amend the protective order. On or about December 14th, 2024, defense counsel and the government met and conferred. So this is the day after they actually viewed the contents on those 9 videos. Defense counsel asked the government to redesignate the inspection only videos as attorney possession only for 2 reasons. First, because defendant needed to access the video's metadata, and second, because the defendant wanted to enhance the audio and sound of the inspection only videos. Later that day, the government responded in writing that, given the significant sensitivity of the materials and specific requests from victim one that the materials not be electronically transmitted and produced, we cannot de-designate the videos at this time. However, we hear and understand the concerns you raise and are prepared to offer the following as soon as possible. One, to the extent that the metadata is missing from the files on the hard drive, we will provide you with all available categories of metadata in a letter on Monday. And two, for the use of both parties, we will work with you to identify a neutral expert who can enhance the image and sound quality of the videos. Now, this makes sense. So the government is trying to work with them to say, okay, you said you had an issue with the audio and video. All right, we could get somebody in to help with that. hmm The next day, the defense responded that they did not believe that there was anything left to confer about, given that the government is not in a position to change the designation at this time. The defense had already hired an expert in connection with these videos and would file a motion with the court. On December 16, 2024, the government provided defense counsel with a letter memorializing all available metadata from the inspection only videos. The government also offered to prepare a forensic copy of the 10 videos, which would include all available metadata for their inspection. Defense counsel has not made any further requests regarding the video's metadata. On or about January 14th, 2025, the defendant filed an instant motion. Let me see. The government understands the motion to request only that the inspection only videos be redesignated as attorney possession only and does not consent the current designation under the protective order of any photographs designated as inspection only. All right. So, in the publicly filed motion, the defendant described at length the inspection only videos using subjective and inflammatory language calculated to embarrass victim one. No sound the language saying, oh, she looked like she enjoyed it and she was dominant and all that other stuff. That yeah. Many of the characterizations and descriptions were unredacted in plain violation of the protective order. That same day, the government requested that the court direct the motion to be removed from the docket and refiled with redactions comporting with the protective order. The court granted that request on January 15, 2025, and ordered the government to respond to the motion by January 28, 2025. The government conferred with legal counsel for Victim 1 in preparing this opposition. Victim 1 opposes any modification of the protective order as the inspection only videos. Specifically, counsel for Victim 1 continues to have serious concerns about the security of such videos, including the possibility of third parties gaining access to the video. Yep, what did I tell y'all? Um, due to the very publicized nature of the case, the possibility of these highly sensitive videos being shared with witnesses, and the defendant's use of such videos to litigate its case in the public domain, as demonstrated by the instant motion. They're trying to get back. They're trying to get back. They're still pissed about that video of Cassie being dragged down the hall. He is still pissed about that. So he is trying to get his payback. Mm, 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 mm. Um, all right, so these are the legal I'm gonna go through the legal standards because we need to understand as to why we need to protect the clients or protect the plaintiff and the victim, and I'm sorry, not the plaintiff, protect the victim in this case. Federal Rule of Criminal Procedure provides that at any time the court may, for a good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief. In determining whether good cause exists, courts should balance several interests, including whether decimation of the discovery material inflicts hazard to others and whether imposition of the protective order would prejudice the defendant. Courts around the country have relied on what is that? It's something victim. I have to go back and look because I totally forgot what CVRA is. Relied on the CVRA to find good cause for entry protective orders. Um, Let me see. The CVRA provides crime victims. Crime victims. Okay. The crime victims Rights Act. So the CVRA provides crime victims with important rights, including the right to be reasonably protected from the accused and the right to be treated with with fairness and with respect for the victim's dignity and privacy. In cases involving SA or sexual abuse, courts in the district have repeatedly entered protective orders that restrict a defendant review of certain highly sensitive discovery materials, including nude and sexually explicit content, to the extent to inspection only review. Um, and that's it. So there's other cases, not just Cassie case, where they have entered protective orders that restrict defendant's review. This is considered highly sensitive discovery material. Discussion. Good cause exists for the protections in the protecting order of this limited number of videos, which victim one has specifically requested requested not be electronically produced to the defendant. As alleged, the defendant filmed and then threatened victim one of the decimation of these videos to ensure victim one's compliance with his will. Do y'all hear that? Further, the defendant's proposal of redesignating these materials to APO is wholly insufficient to address victim one's valid privacy concerns and to ensure that such videos are not improperly decimated. There is ample good cause for the court to affirm the protective order designation of these inspection only inspection only videos. The materials implicate victim one's privacy interests due to their highly sensitive and personal nature. These sexual acts have caused significant trauma to victim one, and disclosure of their recordings would undoubtedly cause particularly serious embarrassment to victim one and potentially economic harm. The risk of improper disclosure is especially salient here, where the defendant is alleged to have used videos of commercial X acts as collateral, threatening to disclose video recordings of freak offs to coerce the victim's continued participation. As victim one texts the defendant in December of 2015, "You know what sick and disgusting ish I was reminded of the other day? You forcing me to, or you would going to leak some freak off ish." In addition, in a text message from a different victim, significantly after 2015, that victim wrote, "He just threatened me about my X tapes that he has of me on two phones. He said he would expose me. Mind you, these X tapes were where I am heavily rugged, I'm sorry, and doing things he asked of me for the past 3 years." In other words, when the defendant had access to the sort of videos, he shamelessly extorted his victims to ensure obedience, compliance, and continued participation in forced and coerced sexual acts. Following the charges in the present case, which carry significant penalties, there is no telling what the defendant would do to discredit and embarrass victims. Thus, ample good cause exists for the protective order's limitations on the defense physical possession of and access to these videos. Good cause for the protective order treatment of the inspection only videos is further supported by the CVRA and the defendant's recent violations of the protective order in filing this very motion. As the defense knows, victim one, who has statutory rights under the CVRA to be reasonably protected from the accused and treated with fairness and with respect for her dignity and privacy in these criminal proceedings, has specifically requested that this small subset of sexually explicit videos be provided to the defense on an inspection only basis. This request is entitled to serious consideration by this court, particularly here where victim one has articulated reasonable concerns about the defendant's improper use of the videos to litigate his case uh, and the possibility of third parties gaining unauthorized access to the videos. The defendant's apparent willingness to violate the protective order in order to embarrass victim one and litigate this case in the public domain, as demonstrated by his filing of the instant motion, underscores these concerns. There is now an even stronger basis for the court to strictly regulate the defendant's access to the inspection only videos. Second, the current designation of the videos are as inspection only does not unduly prejudice the defendant. The government has repeatedly worked to ensure that the defendant has ample and ready access to the videos to prepare for trial. The government agreed not to designate the videos as AEO so that the defendant could view the videos with his counsel. So Diddy, and I just realized that because so Diddy did have the opportunity. So they could go at any time to review as much time as they need, as many days as they want, take their notes or whatever the case may be. So the government is giving them that. But that's not good enough because they have other intentions. The government agreed not to designate, oh, well, I already read that. And the government has made the inspection only videos available to the defendant each time he requested access in advance of trial. The government is committed to ensuring that the defendant has continued prompt access to this material in a secure location. In addition, the government recently provided the defendant with all the metadata for the videos and proposed using neutral expert to enhance the quality of the videos, a proposal rejected immediately by the defendant. So he didn't want that. He want to get his hands on those tapes. See, it's different when you're in there, you ain't got your hands on nothing. When you was at your house, you probably had a whole room full of videos, a whole security system. Y'all know those movies where it be like a little secret room and they got all their computers set up and all these TVs to show different parts. That's him. But he ain't got that no more. Mm. The government will continue to work with defense counsel to ensure that the video inspection only status does not unduly prejudice the defendant. For example, the government is amenable, yeah, to having an expert retained by the defendant view the videos under the same circumstances as the defense may. So they're saying, hey, if you have an expert, tell them to come on. Tell them to come on schedule, and they do what they do. So they're giving them the opportunity. They just want that. mm. In addition to the extent that the defense claims that the inspection only status of these videos is somehow incompatible with his ability to adequately defend himself at trial, that is incorrect. As noted above, in cases involving sexual abuse, courts routinely enter protective orders that designate certain categories of highly sensitive sexual material as inspection only. Indeed, in child sexual abuse material cases, the Adam Walsh Act required that the courts deny all the requests for defense duplication or copying of the child. Oh, yeah, the ICY, which is arguably the key evidence in those cases, so long as the government makes the material reasonably available to the defendant, his attorney, and or experts for inspection and viewing at a governmental facility. And courts have repeatedly rejected constitutional challenges to this law, concluding that it is consistent with due process and sufficiently allows a defendant to prepare a defense. So in no way, shape, form, fashion should Diddy be out here hollering that he cannot prepare for trial because he doesn't have his hand on those freak off tapes. The government is giving you access anytime that you need it. The government is even telling your attorney to hire their own expert. So what's the problem? In some, good cause exists for the protective order's treatments of the inspection only videos. The court should thus deny the defendant's request to modify the protective order with respect to a small subset of videos. Let's see. This says, should the court redesignate the inspection only videos under the protective order, additional safeguards must be afforded. So, meaning that if the government does decide that the tape should be given to defense counsel electronically, then the government wants to provide safeguards so that victim one, aka Cassie, can, be assured that her stuff don't get leaked to the public. Although the defendant has failed to establish a sufficient basis to redesignate the inspection only videos, and his request to do so should be denied, it bears noting that the defendant's modification proposal falls short of other reasons too. In particular, even assuming it were appropriate for the defense to maintain its own copy of the videos, the proposal fails to provide adequate safeguards against third-party access and or decimation. A modification without such safeguards should be flatly rejected. Instead, any redesignation must come with additional protections to govern. How the inspection only videos are stored and maintained, and two, with whom are they shared with? Let me see. So, notably, redesignating the material from inspection only to attorney possession only would actually make these videos less protected than other visual depictions of actually explicit conduct or nudity, which, with the exception of materials on the defendant's own devices, are designated as attorney eyes only. Wait, they spelled two wrong. Oh no, I lied. This two counsels against this too counsels against redesignation of the inspection only video. Okay. I was like, wait, what? All right. So, at the first category of protections, measures must be taken to ensure the defendant's electronic copy of the inspection only videos is securely maintained to prevent any unauthorized access. Consistent with the government's treatment of these videos, the defense should be required to store the videos on an offline encrypted drive in a secure location known only to a limited number of attorneys. Copying, electronic file sharing, or real time electronic streaming of the video to third parties over video conference technology must be strictly prohibited. As a second category of protections, any modification to the protective order should one prevent the defendant from showing these inspection only videos to witnesses, with the exception of witnesses who are physically depicted in the videos or certain expert witnesses. Two, require the defendant to provide advance notice to the court prior to showing the videos to any permissible witness. Three, require the defendant to maintain a log of all individuals who viewed the inspection only video and file such log under seal with the court. Finally, to the extent that the court grants the defendant's authorization to provide an expert copies of the videos to which the government objects, that expert should first have to agree in writing that the videos will be maintained in a similarly secure conditions to prevent unauthorized access to them. If the court concludes that some modification to the protective order is required, the government requests the opportunity to provide an addendum to the protective order that includes specifications consistent with the above regarding how the inspection only videos are stored, maintained, and accessed. You know what? I did notice that. In conclusion, for the foregoing reasons, the court should deny the motion. I did notice that. Mark Agnafilio was going off and off and off and trying to pretty much, because we all know who victim one is, but he did that on purpose. But nowhere in his letter did he say, okay, yes, give us electronic copy, and here is here are the steps that we're going to take in order to ensure that it's not shared with third parties. He didn't do that. His goal was just saying, hey, y'all leaked that Cassie video, we need these videos so we can go do the same. He's trying to do tit for tat. That's what he's trying to do. That's crazy. All right, going into, let's see. We have reviewed the government's January 28th submission. So that was the last letter. All right. So in this one, the defense counsel is asking the court to allow them to reply to what I just read by Friday. So Friday, we're going to get another update. Now, that's okay. Well, I spoke too soon. This is a denial. So this is so the judge denies the defendant's motion to amend the protective order to pretty much obtain access or electronic copies of those freak off tapes. But let me just read it. I'm gonna just read it. It says defendant's motion to amend the protective order is denied without prejudice, meaning that they can be allowed to file again. While the government objects to handling the videos over, they provide several options for the defendant to consider what would permit the defense to view the videos, access the information they are looking for, and even allow them to manipulate the videos as they see fit. To the extent these options are insufficient, the defendant the defense may propose other options to the government because they're not giving no options. The government is saying, "Hey, here are some options." Mark Agnafilio is like, "No, my I won't have it. My defendant won't have it. But y'all are not. You're not providing a solution." Um, It doesn't appear that the defense did this before raising the issue with the court. Ooh. The parties should have these discussions, and then if they really reach an impasse, the defense can come back to the court. If that happens, they should be prepared to clearly articulate why they need possession of the videos despite the options furnished by the government. So the clerk of court, well, the court directed the clerk of court to terminate that motion. So straight denied. I'm saying not she. I'm thinking about Torres. Um, the judge in this case said, "Hey, the government has provided you guys with 5011 ways that you can access this video. They provided you with options and alternatives. You said no, but you never came back with an alternative or a suggestion or a solution." So the judge is like, y'all need to have these conversations. And if for some strange reason it does not work out, then you can come back to the court and I will reconsider. Good luck. Um All right, and so now this is another, let's see. So it says the protective order is clear that the defense shall not share any attorney eyes only material or the content of the attorney eyes only material with any other persons. The defense original letter, which the court stricken from the public docket, did not redact numerous descriptions of the content of the videos at issue, which have been designated attorney eyes only pursuant to the protective order. These descriptions are appropriately sealed under the test of Logos versus Pyramid Company. But to the extent certain of the government's proposed redactions don't relate to the content of AEO material, and the defense original letter can be refiled with those specific sentences unredacted. So pretty much there's two things here. Um First and foremost, they have to go back and they have to ensure, I think they already did, to redact the characteristics and the description of those of the video that they saw, because that is part of the AEO material and that should not have been um because this record here that I'm reading, it's actually public. So now it's not attorney eyes only, it's pretty much for everybody like you and me to actually review. So they have to redact that. I mean, it's already out there, but they still have to follow the protective order. Um, then the second thing is there were some things that the government was telling them to redact that wasn't necessarily AEO material. So the defense can go back to that letter and unredact that and make that viewable to the public. Baby. So all in all, Mark Agnafilio has he's a good attorney. I give that to him, but They do too much. And in this particular situation, I really believe that is tit for tat. Somebody leaked Cassie's video of, him doing what he did to her down the hall. So we need to get a copy and we need to allow the public to see so they can make their determination, their opinions about this case. He wants the public court of opinion. He doesn't want the opinion of the judge. He wants the public court of opinion to try to turn that case around. But y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.